The movement for the Democratic Change leader, that is Douglas Mwonzora, has filed a petition to the Constitutional Court. I think he becomes the first opposition political leader in Zimbabwe to take Mnangagwa head-on soon after signing the illegal constitutional amendment bill number 3 of 2026. I like what one lady who is a Zimbabwean politician said. She said apartheid was a lawful government at a certain point, but it was unlawful. Saying colonization was lawful, but it was unlawful. So this is the period that Zimbabwe is undergoing. We've got the CAB3 bill signed into an act. And of course, it is now lawful in Zimbabwe, but it's an unlawful law. And Douglas Mwonzora has challenged this. Greetings and welcome to your lovely channel, the Hlonipani Global News. If you are watching us for the very first time, please do remember to press the subscribe button so that next time when we beam live, you become the very first one to watch us. So the movement for democratic change, MTC, has filed an urgent constitutional court application seeking to have the Constitution of Zimbabwe Amendment Act number 3 of 2026 declared unconstitutional, arguing that President Mnangagwa was obliged to subject the law to a national referendum before signing it and failed to do so. The application filed at the Constitutional Court in Harare on Thursday cites the President, Parliament, the Justice Minister, and the Attorney General as respondents. MTC President Douglas Togarese Mwonzora deposed the founding affidavit on the party's behalf. Mwonzora stated in his affidavit that President Mnangagwa signed the Constitution of Zimbabwe Amendment Bill HB1 into law on July 7 without subjecting the bill to a referendum first, despite what the party argues was a clear constitutional obligation to do so under Section 110 2F, which places responsibility for calling referendums on the president. At the heart of the challenge is Section 3 of the new act, which repeals and substitute Section 92 of the Constitution to provide that the president is elected by lawmakers sitting jointly as the Senate and National Assembly rather than directly by voters. Under the new provision, a presidential candidate must secure more than half of the valid votes cast, with a runoff held between the two leading candidates if no one achieves a majority in the first round. The amendment forms part of a broader package of constitutional changes. Section 5 of the Act extends the term of office of the president from 5 to 7 years, a change that usually the change that unusually is stated to apply retrospectively to the continuation in office of the sitting president, notwithstanding the Constitution's ordinary rule against amendment affecting serving office holders. Section 10 makes an identical 7-year extension for the life of Parliament, again applying it to the sitting National Assembly and Senate. The Act also makes a string of other changes, including empowering the Registrar General rather than the Zimbabwe Electoral Commission to register voters and compile voters' roll, while increasing the size of the Senate from 80 to 90 seats, with 10 additional senators to be appointed directly by the president. Mwonzora argues the changes to the presidential election model strips ordinary citizens of their right to vote for president, a right guaranteed under Section 673A to every citizen aged 18 and above, and in doing so amends the Constitution of Rights by implication. What the above means is that the right to vote for president has now been removed from the general populace and is now a preserve of only those Zimbabweans who are members of parliament, Mwonzora states in the affidavit. Because the change touches the Bill of Rights, the application argues Section 3286 of the Constitution requires the bill to be put to a referendum before it could be presented for presidential assent. Mwonzora further contends that Mnangagwa, as the direct beneficiary of the amendment, found himself approving a law that entrenches his own hold on office. Precisely the conflict of interest, he says, Section 3286 was designed to guard against. The affidavit also draws a historical comparison, noting that since Zimbabwe introduced the office of the executive president, all qualified voters, not just sitting MPs, have had the right to elect the head of state. The new provision, it argues, introduces a qualified franchise for the presidency and disenfranchises the general populace in relation to that specific election. The MTC is asking the Constitutional Court to declare that Mnangagwa failed to fulfill his constitutional obligation under sections 110(2)(f), 91 and 3286 and to strike down Section 3 of the Amendment Act as invalidly promulgated. As an alternative remedy, the party wants the court to order the president to subject the amendment bill to a referendum within 3 months of its passage by the Senate. The MTC is also seeking cost of suit against the respondents. Now, I want to see really how Emmerson Mnangagwa is going to respond to this one. I think I have dealt with it before. Here is how Mwonzora is coming. Douglas Mwonzora is coming with a very, very valid point that number one, this bill that has been introduced by Emmerson Mnangagwa, it introduces what is called qualified voters as well as unqualified voters. For example, we know in the Zimbabwean Constitution of 2013 that each and every Zimbabwean has a right to vote. And what this act of Emmerson Mnangagwa that he signed into law takes away from the ordinary Zimbabweans is their right to vote for members of the executive, and chief among that member of the executive being the president, who is crucial in terms of selecting other fellow members of the executive. Now, caption this. That right has been taken away from the ordinary citizens of Zimbabwe, and the Constitution makes it clear on 3286 that if one tampers with the right for the citizens of Zimbabwe to vote, now we are not dealing with what many have been arguing about, of which they are also equally right, that if the president wants to deal away with the 2 terms, then that actually bill has to be subjected to a referendum. He is bringing another angle that hasn't been tested by the Constitutional Court, an argument that hasn't been ventilated much by the people of Zimbabwe. That, okay, let's park for a moment the fact that Mnangagwa gets to win with the argument that he was not changing 2 terms. He was not changing 2 terms, but they were elongating the terms. And for a moment, even though that is absurdity, let's appreciate that they are saying the truth. But look, as much if they were doing so, they also introduced another aspect, that the members of parliament will vote for the president, and that on its own, that clause on its own undermined the rights of the citizens of Zimbabwe. The citizens of Zimbabwe right to vote was tempered with the right, and I don't believe only the right to vote, and other several rights were taken from the people of Zimbabwe. Now, before this act was introduced, political parties, opposition political parties, and everyone, even independent candidates, they were allowed to actually field their candidature so that the citizens of Zimbabwe can exercise their right to belong in terms of whether choosing to vote for a candidate, an independent candidate, or a political party. That right has been affected also by this development. Now, by this actually bill, because these rights that this bill tempers not only with the right for the people to vote, but the right for the people of Zimbabwe to choose to associate, but the right for the people of Zimbabwe to choose to belong. All these rights have been tempered with, because even if you choose to belong to any political party at the moment, you do not have the right to choose the member of the executive. So with Mnangagwa tempering around, especially not only just the right to vote, this bill, beyond any reasonable doubt, was supposed to be subjected to a referendum, because as much as he was changing the voting for the president to actually voting for the president being exercised by me and you as ordinary citizens, it also affects other rights that I have actually been talking about. And as such, if there is any bill that affects the rights of the citizens of Zimbabwe, surely under normal circumstances, that bill should be subjected to a referendum. Now, Douglas Mwonzora is not only bringing this. Remember also, the Constitution of 2013 was clear. It defined a term as 5 years. If we are in agreement that it defined the term of office as 5 years, of the parliamentarians as well as that of the president. That is why each and every time, even Mnangagwa, when he was declaring an election date, he will actually quote the constitution that every 5 years elections should be held to elect the president of the nation. Mnangagwa himself, if you look at the proclamation that he made leading to the elections of 2018, the proclamation that he made leading to the elections of 2023, he highlighted that each and every 5 years, elections should be conducted in Zimbabwe. Now, if the Constitution clearly defines the time frame in which elections should be conducted, and also clearly defines that, please, elections should, a president should only contest for 2 terms. Now, if someone wants, now 2 terms is 10 years, that's mathematics. 1 term is 5 years. So time also matters in this regard. Now, if time also matters in this regard, Mnangagwa saying, no, I'm not tampering with 2 terms. The Constitution is silence. There is a lacuna on the constitution, especially when it is actually when with reference to the length of the terms. The constitution doesn't specifically say something, but it says something about the parliamentarians and saying their term runs contemporaneous with the term of the president of Zimbabwe. It was clearly stated. But because, and also, one thing, in order to understand this, that Mnangagwa is taking Zimbabweans for a ride. Look at individuals like Daniel Gawe. Daniel Gawe is on record saying we will achieve 2030 by hook or crook. That on its own, these are the statements that should also be filed in a court of law because they they help concretize this argument that Mnangagwa did this bill crookedly, and even the supporters, they actually said whether we like it as Zimbabweans, they are going to employ crooked ways. They are going to employ unorthodox ways, unconstitutional means to achieve what has just been achieved today. All these issues must be placed on record and be argued at the Constitutional Court. It remains to be seen whether the compromised Constitutional Court of Mnangagwa will also look at a technique to dismiss this case, but I strongly believe this case should be argued right from the Constitutional Court because it touches fundamental constitutional aspects, which is the Bill of Rights. Not only that, it also touches on Section 3286. The court has to actually say something and overlook any other, silly technical error to justify this level, the highest level of unconstitutionalism that is evolving in Zimbabwe. We await to see really what would be their posture when it comes to this matter. Will they treat this case the way they treated the case that was submitted by Professor Lovemore Maduku? Because that case was supposed to be handled by the Constitutional Court. But we know that those judges at the Constitutional Court, they are highly compromised, beginning with the Chief Justice of Zimbabwe and even the previous Chief Justices. We know that they are highly, that is why retired Chief Justice Luke Malaba, upon his retirement, he was actually rewarded with properties worth millions of United States dollars. Thank you very much for watching us. If you are watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us. You can financially support this channel by pressing the join button and be part of our members who are the heartbeat of this channel. You can equally do so by pressing the thanks button and send us stars. Out. Let me love and leave you. Let's meet on the